Uh, It is 11:05. I'd like to call the meeting to order. Can we call the roll, please?
Chair Jean Ambler,
Present.
Vice Chair Christina Ponte,
Present.
Christina Lockhart Wells, Judith Ann McLaughlin,
Present.
Paul Tilka. We have 3 present. That meets the quorum.
Very good. And thank you so much for getting the minutes out ahead of time. Very helpful to be early, so it's fresh in my head. Do we have a motion to approve the minutes?
So moved.
Second.
All in favor?
Aye.
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 Okay. So our main topic is continuing to go through the employee personnel policies and procedures handbook. I would like to discuss one other piece of old business, and that had to do with our drug testing policy. I know I had sent an email requesting that the Board of Commissioners be notified of this. Can we get an update on the status of that policy, please?
Yeah, the insurance company has softened on it and we're proceeding with safety sensitive positions going forward.
Amazing. So in other words, we're still going to get the discount
Yes,
and you're going to go ahead and abide by the
correct.
letter of the law.
Yep, and Rob is drafting our new thank you.
Excellent, excellent. Great
We can
negotiations.
put that one on the back burner now.
Okay, perfect. Did it ever
Good
go?
job, Sean.
Yeah,
Good job.
excellent.
Well, it was actually Karen who did a bunch of the work, so the shout out goes to her.
Thank you.
Okay, well done. Thank you very much. I will definitely sleep a little better knowing that that's behind us. So, did it ever have to go to the board or did you folks on your own?
No, we took care of it.
Perfect. Yeah, because I was looking at the minutes, didn't see anything. So that's great. So, all righty. So our main topic for today is to continue with the draft, but I was just advised by our attorney that he's not going to be available for our next scheduled meeting. And
There's actually quite a few conflicts in November. We'd like to move it to December.
that's okay with me. How about the rest of you? It was the 16th at 1 o'clock at 11 o'clock.
So we're taking that off.
Yes.
Mr. Lilly, what day in November are you looking at?
No, December. It'd have to be probably, yeah, the first or second week.
What about like December 1 or December 2?
December
Work.
1st, we could do.
That's a Thursday or a Friday. My worry is that I've got a 3-week long federal trial and I'm set for the December trial calendar. Federal court doesn't give you a day. It says be ready to go in the month of December, but I'm guessing that my first day of trial would be December 5th. And it's a constitutional case, so it's not going to settle. It's going to definitely go to trial. And so if December 1 or 2 works, that would be the most certain that I'd be free.
The first is fine, as far as I'm concerned.
The first works best for me because I have to have qualifying packets out on the 2nd and I'll have people coming and picking them up.
Judith Ann, how about you?
I could do the second. Or the first.
Oh,
Christina, how about you?
I can do the first or the second.
Same thing. How do you folks feel about doing it late in the day? 3:30, you said, Judith Ann? Is that, or?
Yeah, I'm gonna get my daughter at school at 2:30. So, yeah, 2:30 would be safe.
but would the 30th help? I mean, it's practically December.
30th is great for me.
What time?
Okay.
4 or later? That's. Christina, how about you?
Okay with me.
What's the preference of the city? Either Wednesday at 4 or Thursday the 1st at 3:30?
Wednesday, I think is better for me.
3:30 then?
Well, for Wednesday, you said.
I'm sorry,
4.
4 o'clock. 4 o'clock on Wednesday. All right. All right, are we ready to carry on and to dig in? Before we get started, any other comments or feedback from the city? Nope. Okay. Okay, we were, if I can get some help here on section. Oops. I apologize. We went up through section 604.
Actually, before we get started, can I just, I thought of something for clarification on the drug testing policy. How is that going to proceed and how will we know, it gets done and implemented? So the next step is he's writing a new
Correct.
policy and then,
The city has ceased testing everyone.
Okay.
Just because that's what the law requires, even though the words don't say that yet. They've asked me to look at their current drug-free workplace policy and give them back any edits that are needed.
okay,
And so that's pending. Once I give that back to them, the manager will look at it and implement it.
okay. So it's
We-
already
we
been,
treat it
you've
as a
already,
separate document.
okay,
So the
It's-
employee signs for the handbook and also the drug testing policy.
okay. So it's already been handled by stopping,
being
okay,
worked on, yeah.
effectively.
By the
Okay,
time,
thank you.
the next meeting by the time of your next meeting, it will be done and
Okay.
so forth. And Mr. Lilly will probably, give you all a copy of it as a courtesy to just so you can see what it
Fabulous.
says, but.
Okay, thank you.
Okay, I'm looking in the printed packet. Maybe it's on this page. No, those are the minutes. I'm looking for the comments that people submitted.
I didn't receive any.
No, we didn't receive any. Okay, I had sent them previously. I'm sorry, Claire, I can't hear you.
Thing we received, to my knowledge, that I'm aware of is the drug testing information.
Okay, I had previously sent comments.
Right.
Page 57 of the June 2nd packet.
August packet. Thank you. That's why I am not finding it.
Let's look at those up through. So would you like to borrow mine?
Yeah, I would love to. And this way we can move things. I'll pass the April packet. Do you mind if I borrow it? Thank you. All righty. Then I believe we made it through section 604. Is that all righty?
Consistent with the notes.
All righty. So next up will be section 605.
And actually, one more question for clarification, that the version that's attached to today's notes, is this include additional updates from the city since the last meeting?
Yes.
Well, all of the green relates to your suggestions.
Okay, perfect. May we, I don't see an identifier on this version. Is that like, I think this had been suggested in the past. It's just like put labeling on the front or something like that, so we know which version. The versions are still pretty confusing.
8/23/19 on the front page.
23/19, that's 2019. Yeah, I agree. I thought that was also an identifier, but I don't think it is. That's from 2019, but looking
yeah,
for
you're right.
that's okay. It's just so we can keep all these versions straight.
I agree.
I thought
Yeah,
I had the date
that's,
on there.
That's okay. Maybe it is somewhere else, but maybe just on the front somewhere or,
Yeah.
or on the page numbers.
and the fact that this is a draft, so, draft
Yes, draft,
version
yes.
and then the date of,
Yes.
that would be helpful. All right.
Thank you.
For that. Now. Page. Page 605 in section 605, which is on page. Says 27 of 94, at the bottom right. Any comments or thoughts on insurance? Okay. 606, retirement. Any thoughts? Okay. 607 is tuition reimbursement. I have two comments that I had written before. That on the attorney draft document, there's a reference to veterans leave. Do we need to address this?
I think that's the next section. Tuition reimbursement is
Yeah.
the
607.
607, no, 606 on the original tuition. Did you skip over tuition reimbursement? Because I have a note in here. You said retirement and then tuition reimbursement was next. And for that, I have a question about other professional development.
Oh, maybe the sections changed names. I
They
see.
did, they
yes.
changed numbering and
So-
Yeah, we
also
added
it's
one.
up
I'm
on,
sorry.
the-
Oh, okay, thank
Yeah,
you.
see the green
Tuition.
number, like it changed 606, 607.
and she also does
Okay.
have it up on the screen so that we can all.
helpful.
Yes.
Okay. Christina, you've got a comment under tuition reimbursement then?
Yes, so I think in the attorney's version, there's more elaboration on other types of professional development and honestly, on other types of professional development that's not strictly courses. And honestly, I forgot my version of his document. So I don't know if either of you have that available, but there was additional this section seemed to be lacking in what it,
So
in what it described.
I do
I
have.
do have it. I'm
Seven.
trying to find
Okay.
Yeah, 6.
Section XXI 21, so, section 21 is what I had it as.
Would be 606 in the attorney's version.
Did you want to take a look to jog your memory?
You don't mind. Yes, so this is the attorney's version is far more comprehensive as far as professional development options. I did see in our, the city's version, there was more information about training particular to HR, but in the attorney's version, what I see from the Madeira version is it's predominantly tuitioned college courses. Let me see. Tuition, whereas this reads, and is it possible to bring this version up on the computer as well? Is that something? What was it? Not on the agenda? Okay, so this says, encouraged a well-trained, educated workforce. The Board of Commission desires through this policy to provide training and education opportunities for its employees to the fullest extent allowed by the law. HR is a clearinghouse for all education opportunities, not including but not limited to development of training programs for all employees, yada, yada. And there are just, it's more robust as to what they offer or what is being suggested, including non-degreed courses or seminars. So,
We typically reimburse if they're job related.
I'm sorry, can you
I
repeat?
guess the recommendation would be to consider the professional development program as outlined in this document and determine if there are sections that
Yeah, we can
should,
look at it.
yeah, I don't know that I have a more concrete recommendation at this point. It's far more robust.
So if I'm understanding you, the main difference is that the city version speaks to courses taken at college degree related, whereas the attorney version opens it up
Yes,
to
I think
other.
that's yes, there is a larger allowance for more education.
Hmm.
And it may be something the city wants to consider.
For example, seminars or,
Yes.
That is something.
We do pay
already
for that
do.
stuff, but
Yeah.
we can look at putting it in here.
Like in the city clerk's office, there are certifications we have to get and stay up on public records law and all that. And building department, of course, permitting specialists, they have certain building code classes that they have to take too, and it's prepaid or it's, it's registered. Part of this, their program with the city.
Christina, what's your specific suggestion then on how we proceed?
Is it sufficient to say review and consider incorporation? And then we can discuss at the next meeting if there are outstanding, because I think Sean's done a good job of, updating based on that. I mean, there are things such as reasons why, or it's pretty in-depth as far as like when you can or can't use work time, attendance at training workshops is permissible during work hours with prior approval. There's a lot in here that's not covered in the current city version. So I think
We'll look
that.
at it, no problem.
Thank you.
Thank you. Okay. Anything else for tuition reimbursement? All right. Then the current section 608, formerly 607, leave of absence with pay. And here we include jury and court duty. And so on. I remember reading that the attorney draft document refers to veterans leave.
Yes.
Do we need to address this?
But we have reserve training and active military service.
It's on page 56 of the attorney version. So.
Oh, their disabilities.
Yes, I had disabilities. I had disability workers' comp, although I think that's covered elsewhere. But it does seem, logical for anything related to you don't have workers' comp in this section, right?
No, I think it's in another section.
It's in another one. Okay. Reporting injury, life duty work.
Yeah, this has to do with if an employee has incurred a service-connected disability and you're being scheduled for treatment, they should be granted veterans leave for such reexamination of treatment.
But we would do that anyway. I mean, if somebody's being treated, they have a disability, it's likely they have a disability, so under the ADA, we would give them the time.
Okay. So is there a reason in the attorney version that was spelled out specifically for veterans? Does it need
First
to
of all,
be?
the ADA doesn't have anything to do with time off. The ADA has to do with, can you perform the essential functions of your job with or without accommodations? If you can't, then you need to look to leave, which may be covered under the FMLA or not, but the ADA doesn't have anything to do with time off work.
But it could lead
The
to
provision is there, and all the provisions of the draft that I had done on military leave, I think is the overall section title, comes out of a combination of the Florida statutes, what they have to say about it, as well as there's a couple of federal statutes that address it. And so that's why it's there, because, if either the legislature or Congress spells out something that has to do with public employment, I tend to try to want to put it in the policy. It's, my client may say, well, we would do it anyway, whatever. I just think it's better that everybody, employees and management, understand what is required. And it's written right there, so you could open it up and read it and everybody will know. And you don't have to rely on having, a competent HR person there or whatever. It's there for the whole organization to know. So, I mean, that kind of theme is why mine ended up being as long as it did, because it's the way it's always going to end up, because employment is a complex thing. So, just like with the prior tuition benefit thing, it's longer, but it provides all the detail I think that you would need for degree seeking versus non-degree seeking, career development, all those things. It's just all spelled out. So I think that maybe the recommendation is to ask Mr. Lilly to look at the military leave, all the military leave provisions, and compare them. So what is being proposed, and see if he wants to come back next time with changes.
And I'd like to add to that. When I'm calling something out as a difference between yours, to me, it's not just length as in he's spelling it out more clearly. To me, there's differences in the content and it's a missing. So I think that's, some of yours is a little bit very prescriptive and theirs is, on the other end. So I think we have to meet in the middle somewhere, but I think the most important thing is, being covered and having the content there in this one. I think that there were differences in the military leaves that were addressed in the city's version.
Well, and it's, I think to further the whole conversation along, it's my presumption, and y'all know from the history of how this whole project started and everything. I met with both the former manager and the current manager, and so I'm operating off of the presumption that the management team has read what I produced front to back and has actively decided, other than what they've already included in their draft, to not include it. And so when you all say, can you please look at what the attorney drafted and staff says, okay, we'll look at it. It sort of, I don't understand that response because I would assume that staff is going to be able to come to you and say, we did already look at what the attorney produced here. Here's why we chose not to put it into our draft. That really should be moving forward, I think, to create efficiency, because you guys seem to have a theme where you're looking at something I did, you're saying, why didn't you? And what staff says is, okay, we'll look at it. Well, you should have already looked at it. You should already have a position. If you think it's good, put it in your draft. If you don't think it's good, explain to this commission why you don't think it's good.
That seems fair. Is that the approach that had been taken? I'm still foggy on the history and the layout of this.
History goes back 2 years. But,
Yeah.
But
No, I kind of disagree with that because we have, multiple minds working on this now.
Yes, sir.
So, you'll bring up something that maybe I haven't thought of, and all that. I mean, we do go back and we do review the attorney's version and the changes are in green. So-
did you, Sean, had you, and again, excuse me, to me, there were switching of hands and managers, and I don't know who, had you in-depth reviewed, you personally, Sean, the attorney's version at that time?
Yes.
Okay. And was the conflict the length? Was it not that you, did you guys go through article by article and say, we don't agree with that, don't agree with this, or was it wholesale? You weren't ready to adopt a full
We did,
change?
and it was during a prior administration.
Okay.
So
Is that available, that review? You went article by article
we
and
would
said,
have had it. The very
Okay.
first version, you would have seen the blue, which was,
and
the
that's a
prior city
reflection of, yes, I'm adopting that, and no, we're
Correct.
not adopting. Okay.
Sean, I agree with you. I mean, we might move quicker if we just made the assumption that you've considered these things, but I agree. We've got a different set of eyes looking at it. And so I would like to continue, with all due respect, that if we see something and then we ask you to reconsider, specifically in the attorney version 7E military leave, if you're willing to tell us you already did and you're not interested in adding it, or now that several of us have said we think that's good language, are you okay with
yeah, we'll go back and review.
go back and reviewing?
Yeah, no
Okay,
problem. I mean, I believe this is a healthy exercise, quite frankly. I think it's going to be beneficial at the end.
very good. Thank you. Any other comments on that particular section, 608?
Yes. Go ahead. You go ahead.
I just had a question about the bereavement leave, and it's got employee's spouse, but what about partners, like domestic partners? Does it have to be that you're married only to have a domestic partner benefit?
Well, so the question of same-sex marriage is now resolved across the fruited plains, and so anybody can marry anybody now. And I think really it's a business decision for Mr. Lilly and the manager. But if you operate on the theme of what used to be domestic partner because homosexuals couldn't marry, and this was a way to sort of give parity to them, now that they can, you're really going to potentially create an issue of, okay, what if I'm a heterosexual couple and I'm just living with my heterosexual partner, but we're not married? And so as a policy decision, you could say, well, yeah, we want to give benefits to you too, but that could then greatly expand the burden on the city staff's ability to get the mission done. And it could also open up the door to abuses of who really is a domestic partner and what does it take to prove that and so forth. So I think on the legal side, the whole domestic partner thing came to life because same-sex marriage was not recognized in many states. Supreme Court has now addressed that. It is now recognized, it is now allowed and happening in Florida. So if you're a married couple, whether you're heterosexual or homosexual, it doesn't you're gonna get the benefit of the city policy. If you then again layer on top, if two people are romantically living together, does that also cover? Legally, you could do that, but I think staff will need to think through what's that going to cause, in terms of even more people looking to benefits, and is it going to expand to, are we going to have to provide insurance coverage and, all the things that typically employers have afforded to married couples. And I'll hand it over to Mr. Lilly because it's really a business decision.
Oh, you want an answer? Sorry. Like I said, I think marriage equality sorted all that out. And it does become messy. I've been involved with administering domestic partner policies and all that, and it gets really complicated at times.
That's, Judith, and do you have additional comment based on what you read or know?
No, I guess it's the transcripts of business decision and that to now, and I was strictly homosexual, I was actually heterosexual. But, over our capacity. Sort of a common law.
Yeah, just to give you a little bit of a background, we've had, well, not here, but in previous jobs, when people trying to get the roommates benefits and things like that. So it just gets really kind of.
Right.
That's why most cities only allow benefits if you're actually related. Gender doesn't matter, it's just relationships. So your employee spouse doesn't matter if it's the same gender or whatever. Has to be somebody that you're related to. Again, not a roommate.
Can you
No.
make, I'm sorry,
No, that's,
can you make do you make exceptions to
we
that?
currently do not.
Okay,
Cities have provided exceptions, sort of, by creating domestic partner registries. And so if you're not married, but you register a domestic partner, and that's primarily in states where same gender matrimonies were not allowed, but that's been taken care of. But again, we provide all benefits. You must show a relation, either as a spouse or a dependent, a child, et cetera.
And when you talk about exceptions, I know you're asking from the heart, but the heartless lawyer would then need to tell, well, I mean, that's my job,
Yes.
I would need to tell management, you need to be careful about that because as a public employer, we are government. And so we're bound by the Equal Protection Clause. And so if we go randomly making exceptions for, well, we'll give you a benefit because we like you or whatever, but we won't give you a benefit, then the lawsuit comes, you're violating Equal Protection Clause, blah, blah. So that's another reason why, you have to spell it out in great detail.
that's why I'm asking. I'm because of that, to make sure we're not making exceptions, or if there was a way to make an exception. That is I think you're even homosexual, heterosexual, regardless of, that. I think the question is, maybe you don't believe in the institution of marriage. Is that more of the realm that you're?
Then that's how you would create a domestic partner. That's what a domestic partner registry is. And
And we
cities
don't
have,
do that currently.
cities have created that. To
Okay.
my knowledge, the city of Madeira Beach has not done that. I believe only 2 cities in Pinellas County, but I could be
Okay,
wrong. When I was in Clearwater, we created one. And then the city that I came from also had a domestic partner registry.
has there been any question of that in your,
Here,
Yes.
I haven't.
No.
I
I
don't-
haven't run into anything.
okay, I guess maybe would it be suffice if somebody brings it to them that we consider it, or is that something to proactively address? Would you consider doing a domestic?
Oh, I'm supportive of, I always have been. That's why I've
John?
been criticized when you look up my
100%.
name.
100%, but like I said, it gets messy.
Well, you extend, it's a benefit and you would extend the benefits to somebody who is in a domestic, as long as they have completed the process to be in the
Apply.
domestic partner registry,
Okay.
then they in essence become a dependent.
And your opinion on this?
What you get, it's a policing nightmare for Mr. Lilly is what's going to be created, because unlike marriages, which are, you can quickly read the public record when a judge has given you a divorce, there's an order that's entered and so forth. And as well, you can see on the front end, there's a marriage license. So it's very easy for Mr. Lilly to say, this is our benefit, here's who it's given to, and we can prove very quickly whether you're married or not. If it's domestic partner register, first of all, the city's gonna have to go through the awkward, could be awkward process of setting up. What are the criteria for getting on there? How many months or years should you have been living together? All that kind of stuff. And so then once you go through all that, then Mr. Lilly, and I've seen this too, is going to have to follow up on, okay, when the breakup happens, which is not acknowledged in the public record unless the police get called, as the fight happens. But that you don't know who's living with who anymore. And then all of a sudden the rumors start flying around on staff. Well, they're so-and-so still has so-and-so on the insurance, even though they haven't lived together for 4 years, and so now we have to do investigation. It just gets messy. And I think this is one of the things, that's a good conversation to have, but you formulate your benefits package based upon the needs, wants, and desires of your employee base. And to be able to let them feel, okay, I've got wages, but then what else, got a lot of kids, so let's offer robust insurance. So I think it's one of those things where if management or the commission were hearing a lot of feedback from staff of, gee whiz, we're heavy on the younger, we're living with each other, none of us believe in marriage, but yet we're in our committed relationships and we'd like to have insurance coverage for our significant others, give us this benefit, then that might be something that management considers. If it's not a hue and cry from the employee pool, it becomes an academic exercise.
My suggestion, read City of Clearwater and City of St. Petersburg. They created domestic partnership registries licenses, and they list all the process and how it works. So, that's why, if that would be the direction or suggestion, we would certainly explore that as well.
So if I'm understanding, you're in favor of doing something.
Oh, yeah, if that's your
like
suggestion,
this.
I've never been opposed to not having a domestic partnership, domestic partner registry. We currently do not. I don't know if it's been brought up before at this city, but I'm supportive of it.
I almost feel like it's an item to table. It sounds like there's a lot involved and a lot of work, and it doesn't seem to be. I mean, we have a couple years to continue discussing these things, right? To me, that almost seems like unless somebody else disagrees, I don't know that that's a priority at the moment. Judith Ann, do you, hearing what it entails, and do you different opinion?
I was just looking at in terms of the bereavement leave policy, I can imagine, couples who live together, who have children together, and to say that that person's partner, like they couldn't take time off to go to the funeral, seems not modern age appropriate. However, I do see what you're saying about the ripple effect and the slippery slope of the potential of other benefits.
And you would
in
allow
addition
them to
going
take
to a funeral. You could take
sick or
unpaid leave,
personal, yeah.
right?
They could take vacation leave or unpaid leave. I mean, management's going to be, especially in that kind of situation, if it's a genuine true thing. But in my experience, even when you restrict bereavement leave to family, you still get abuses. I'm so bereaved that my third aunt twice removed, who I've met never, who lives in Poughkeepsie, has died. So I've got to take 3 days off to mourn her loss. That's what you get. And so,
Death is a difficult thing, obviously. And, in my prior jobs, we've made exceptions to it. You're not going to tell somebody they can't go to their partner's funeral.
All right. So it sounds like we're going to table it. Just a question for procedure. If this were to come up as a request, would we have to go back and rewrite the handbook to incorporate this?
I don't think so. I think we'll just include domestic partner because all the benefit stuff would have to change. So I think it's like a different side of it.
So one of the things that when we're done here with this project and the document is ready to go forward to the commission, there will be an ordinance that lays on top of it that adopts it and also creates a whistleblower rule. And in that ordinance, I'm going to propose to the commission that they put a provision that for future revisions of the personnel manual, that could be done by resolution. So it's a bit less involved. So then, if management decides to go down that road or make any other changes, it will come back to you and say, hey, let's look at this focused topic and work out the language. But then to go to the commission, it would be a simple resolution instead of going forward with a double hearing advertised ordinance.
Thank you for that. Good discussion on this. Can we move on? Okay.
I do have a question in the same section
Sure.
still. Can maybe in here somewhere else, but where is disability covered?
Sorry,
Disability? I'm sorry.
Ability.
Yes, sir. I had a note here and I can't remember if I found it elsewhere, but that
Section 1102
1102.
is one section titled disability.
Disability.
It's referenced in the EEO Affirmative Action Program in section 1211.
With pay. I don't think that
It's pretty.
I saw anything that states anything about reasonable accommodation. I think that was my biggest catch. Is there anything in here that you know of that, I believe the attorney's version went into detail about reasonable accommodation. I think that's all ADA. And again, I should have refreshed my memory, but there's nothing that says in here that there's a lot of information about how the city, makes reasonable accommodation, and will support that in the event of a disability. I don't think 1102 covers
It doesn't cover.
that. It's very light. So I did not find that elsewhere in the attorney's version. It fell into the leave with pay. And I don't see a lot of that. And honestly, a lot of the ADA language I did not find in the city's version.
Take a look.
And maybe
Well, it's a federal law that we
Yeah.
have to
So-
follow, but I don't think we list every law that we have to follow in the manual, but it can certainly be included.
So I think the intention of a personnel policy is to give everybody in the city who works for you the ability to understand the most pertinent and salient rules. And so I think that one is, I would think that that's something that people you'd want to be forthcoming with and also make sure everyone on your staff understands, because that's an important one. We're also trying to prevent people that don't know all of the laws from, not everybody's going to know, and all your managers are not going to know all the laws. So you want to make sure they have those. So that's really where that comes from. I don't see enough.
We can add that to section 1102. Since it's titled disability, and I would just added another paragraph into the leave with pay section.
How, can I ask, how many, to just set the stage a little bit, how many managers are responsible for implementing this policy? Like, how many managers do you have and staff?
Oh, managers?
Yes, sir.
Well, that we have 8 department directors
Okay.
and then about another dozen managers, supervisors.
Okay. So.
This document is provided to every employee upon hire.
Yes, sir. And for me, and I think this might be helpful. I think the goal in what we're doing is try to help you, help our city prevent any lawsuits, any issues, and make sure that it's done in a way that's implementable and understood. We're not worried about you or Sean understanding the law or policy. We're worried about everybody else under you guys that, we want to make sure it's all clear and documented for them. And, so
Sure.
that's when I say something, that's where I'm coming from. It's not about you understanding it. It's about the people that need to manage their people. So in that vein, I had another question. Do we have, and are we as a commission allowed to ask for employee complaints or other feedback you've received in the last 2 years, say? Is that available?
It's a public record. Sure.
Can I make that request? Because as I was reflecting on what we're doing, to me, our goal is to help prevent any issues. And that comes from, in part, you have a nice employee complaint procedure and understanding if your employees, have issues that are being dealt with in this. And, that was, what do you all think about that request?
I haven't had anything since I've been here.
Yeah, the several that I can recall were verbal
Okay,
of an employee either going to Sean or to myself. And it involves either, I think the majority have involved a supervisor of that employee's direct supervisor. One, I believe, involved two employees that got into a verbal altercation. But I can think of three in the nearly 11 months that I've been here, and they were simply verbalized. And but two of them involved the employee and their direct supervisor. So concerns about how the supervisor was treating the employee.
okay.
So,
Supervisor,
and
how is that handled?
well, we spoke with both employees and we expressed what the expectations were to the employee.
Was that
and-
documented?
See, I think there is, for one, it was.
Yeah, the one is. The supervisor one, I'm not sure.
Yeah, the one that involved a supervisor, there is some documentation, so we can provide that.
Well,
To
should
you
they
if you
be, and this is, again, part of the discussion is a personnel policy helps manage people, make sure they can do their jobs and, that we don't,
Well, I will tell you that all three incidents specifically dealt with personality. It's something that no manual will teach you. It's how you interact with your employees or how we interact as humans. It was really just a personality issue. It's how one person felt they were being treated by somebody else.
and
Has
so-
nothing to do with a manual
Sure,
other
but,
than,
and the manual should describe how we address, like how we document that. So if this becomes a repeat problem,
I
That-
think you'll find more of that towards the end.
okay.
yeah, that's in the
Yeah,
grievance
I think
part.
so.
Okay, and that was, so that was, so it sounds like there are no, in the last 2 years, no written issues. And so we can revisit when we get to the grievance policy. I would like to hear more about those and see if we think that those were, what we have in here reflects what was done. And if we should be documenting each time there's even a verbal, something like that, so that if this becomes.
No,
No?
please don't. do
Don't?
that.
No,
Okay.
Let me, just give me 2 cents and
Yeah.
we'll get to the discipline thing later in the manual, but
is.
so I think management, the management team has to have the flexibility day in and day out to manage its staff to get the productivity and the conduct that they want, the work performance and the conduct that they want. So if you have a situation, which sounds like these examples were, where they didn't previously occur, but then somebody came to Mr. Lilly and said, oh, my boss is picking on me, whatever the issue is. At that point, I typically would prefer that the upper management just bring the supervisor in, sit people down, talk it through, deal with it, whatnot, and admonish them and tell them, go on your way, be better, whatever it is, and just keep that in their mind. A lot of times when I do management training to the management teams, I will recommend they keep a spiral notebook and just jot things down. And those things may make their way into the annual evaluation where, okay, interpersonal relations, overall, you've done well this year. However, several months ago, I had to counsel you, whatnot. But other than that, you're doing well, 4 out of 5. And that's where those things, if they're come up in writing at all, that's where they come up in writing. But then if there's a situation where that same supervisor is now on round 3 of having staff complain about the same things, at that point, management will say, okay, maybe we have a problem here. And they could either deal with it by demoting the person because they really don't have leadership skills that are needed, or probably to give them a bit more of a chance to start the progressive discipline steps and maybe give them an employee discipline notice and a day off or 3 days off or whatever. And that's where you get into documenting. And in that first document, I would usually tell management, refer back to your verbal, because if a jury ever looks at that, then the jury's going to say, okay, you guys were being reasonable with the supervisor, right? You tried to work with him verbally, you tried to work with him verbally again, 3rd time, okay, now we have to have a day off. But I'm seeing that you're not just reaching for the shotgun, right away. So I wouldn't be I wouldn't be advocating that every single interaction that management has with either employees or lower level supervisors on what something that could be counseling in nature, that makes it into a written document. I think that's, first of all, it's kind of impractical to do, creates a lot of public records in a file, but it also can lead to an atmosphere of us versus them, and, oh, they're trying to paper my file, they're out to get rid of me. And I think, if management has the option to just sit people down and say, let's talk about this, that helps build a relationship between management that should exist.
That makes sense to me. Thank you.
But we do.
These are all really good points, but I think it begs the question of what is the role of this group of people when we're not working on this document. I know it's a subject that's near and dear to Paul's heart, and he's not here with us. I'd like to suggest that, we save this for a future
Sure.
time.
Yeah, that's
But,
actually, I'm sorry, that's actually.
I do have a question. If we weren't going through this, and yet by charter, we're required to have 4 meetings a year. I don't mean to sound facetious, but what the heck would we be doing at those meetings if it weren't for this?
What did they do in prior years? I think some staff was here, but they probably reviewed the manual would be one
Well,
or two. I don't.
Yeah, I think so. First of all, you're going to review your manual to make sure that everything's running well.
Mhm.
Second, you're going to be asking your manager to talk about the benefits packages and whether, what are we doing to keep our pulse on the finger of our employees, make sure they're happy, that kind of thing. You'll be asking your lawyer, are there any changes in the law that we need to implement? So there is a role to play. And in those 4 meetings, and I did see that, and I'm not a big advocate for you must meet 4 times a year. That's kind of a bit much for me, but it's in the charter, so it'd have to be a charter amendment to get it out. But in those meetings, you can also ask the manager and the HR director to give you sort of that quarterly update of what's happened this quarter. How have there been any disputes, whatnot? You don't have to name names, but could you talk about, and that might make you all think that maybe we need to have a policy tweak here, a policy tweak there, or even conduct a training, on things that might need to be done. So there's business for you guys to do 4 times a year.
Okay.
And
Thank you.
how about, Sean and Rob, and anybody else, what would you like to see accomplished in addition or different than that? How can we help support you?
I think Rob stated it. That's pretty much the role.
Honestly, this is my first go around with the civil service.
Yeah,
Commission, so-
I will tell you
Ours
that
too.
civil service commissions are not around. They're really not, there aren't very many cities that have them anymore. From my perspective, in 28 years in local government in 3 states, they're kind of something that's outlived its course, but that's my thoughts on it. But it's still in this city's charter, so it's going to continue until such time as it is no longer in the charter, if that would ever happen. So I don't.
Well, like
I
in
think it's a
St. Pete,
pretty
they have
good
a
thing.
civil service board, but they are solely focused on hearing termination appeals.
Yeah.
So
And others that deal with unions, and we only have one, we have one union, the IAFF. So typically they're for larger cities when you have multiple unions, and again, hearing grievance cases and disciplinary matters.
I think it seems like a good thing. If my company had this, we'd be doing a lot better on HR. So I hopefully you can see it as a
Yeah.
positive,
Oh, yeah.
just a yeah. A
So
different
I'd like
thought.
to suggest that we visit the role, but not until we complete this document. Is that
Sure.
fair? Obviously, if there's anything urgent that comes up, I trust that you folks will bring it to our attention. But we'll revisit the role and.
Yeah, luckily well, knock wood. We really don't have any discipline issues.
That's good.
You didn't just jinx us, did you?
Probably. Now, we did have a couple. We did have one issue with a person that never completed the training they were required to. That was probably the biggest thing that happened, but that was before Robin.
Wow, kudos to you folks. You must be doing a good job.
He ended up quitting, so.
I would think maybe as we move into after we complete this task, having some kind of quarterly review would be fabulous, like some kind of, however, I don't know if you already do something like that, but something that tells us like, like, I don't know if you get annual performance reviews is a good way to, I don't know if you do exit interviews. That's another great way we get feedback. Just really trying to help you look at how you, another one is employee retention. Do you guys have good employee retention?
We do overall. Certain
Okay.
departments, it's a little more difficult, like sanitation,
Sanitation and
public works.
recreation but again, because we have part-time employees in recreation. But we were not competitive wages for sanitation positions and some recreation, but now we've made that correction with the adoption of the fiscal 23 budget last week by the city commission. So wages our minimum wage in the city is now $15 an hour, where it was 13 and change, I believe.
1250.
Or 12.50, now it's 15, and our sanitation, the minimum is 18
Okay.
an hour, which again is what other cities around us, Treasure Island, St. Petersburg, Gulfport were charging.
And recreation primarily has the turnover because it's mostly college kids working there. So
Okay,
they come and go. from
that's
school.
normal.
We
Yes.
keep them inactive but employed, and when they come back, we reemploy them, I guess, activate them.
Can we go back to the employee handbook? Good discussion.
Yeah.
Very good. Thank you.
Just gonna mention back to your question about disability, there are sections, the workers' comp, and then there is a transitional duty assignments. It's related to the on-the-job injuries, but I don't know if we want to take that or incorporate or what you had in mind with adding disability and accommodations someplace.
Where is the workers' comp area that you?
So page 30, it also says 37 of 94, section 805. So it's under workplace safety. So it's section 805 and 806. And 806 also deals with taking leave. But I think those are disabilities related to workplace safety.
Does this say anything about making, what was the word I used? Reasonable accommodations? Is that in here anywhere?
So
I-
workers' comp's a little bit different. That's a whole separate set of laws. But generally, we will try to make accommodations to somebody to get them back to work. So
And I think that that's the part that doesn't,
that's transitional duty.
Section 806.
okay. I would just leave it as review and see if there are differences that looking at the taking leave, working.
I'm just looking to see if it's also covered under anti-discrimination policy.
Should be there. It's not.
Yeah, I see handicap listed.
I've failed to document specific language at this point, so I think it suffices to say, let's review it, and I'll review if you make additions and see if I see any other, misses or anything that I feel that, after additional review, anything that's specifically missing. But the answer was in sections 804, 805. Part of my question at the time of reading it was, is disability covered in the section on leave of absence with pay? I don't see any language specifically there, but we named some other locations. So I'll look back at those 11:0 something. I think that suffices on that item for me.
I had made a comment, section currently 608 having to do with FMLA. And just so you know where I'm coming from, where I currently work, we had a number of abuses and it was a very hot topic. So that's why personally I was a little concerned that the city version has 2.5 pages versus 10 pages in the attorney draft document. So I just want to make sure, I know in the cities, it's right away up front. I like you say, it's intended to set guidelines. It's not the entire act.
Most
So you
peop-
set the stage for that, but I just want to make sure that we're not at risk, or is there anything else that we should have in here?
I don't think that we're at risk. Employees are aware they have FMLA. I want them to come to me because it's,
It's
for somebody that
complicated.
hasn't done it before, it gets pretty complicated.
Yeah.
You know, especially when it's intermittent and all that. So I prefer to be a little bit more vague. So the conversation happens, you know, so that's just my personal opinion.
I'm supportive of that.
Yeah.
So, but that's just my opinion. Has FMLA been an issue here at the city?
Not since I've been here.
How many people, let's say in the last 2 years, have applied for and been granted
No one.
FMLA? Pardon?
One.
0? Wow,
We have a pregnancy coming up, our first one.
wow.
Oh, that's right. Yeah.
Oh.
I forgot.
Congratulations.
Yeah, just, we've only had one in the last couple of years.
That would be Megan, and then
Yeah,
we have an employee that's expecting, so that'll be.
Right. So again, because we're quite small and our employees are a little older, excluding recreation.
All righty. Unless anybody has anything else, I, in this case, want to agree with Rob that the assumption that you folks read through his longer version, but you're comfortable that,
Some of Rob's version is in this.
yeah.
Oh.
Okay. All right. Anything else for section 608 on FMLA?
The only general thing I would say that I didn't find, but Mr. Lilly it may be in there and he can point us to it. I feel that there just needs to be some place where we explicitly say, if at the end of the day, when the sun sets and we've worked with you as much as we can work with you, and you're still physically not able to perform the functions of your job, that you will be separated in a non-disciplinary manner. Is that explicitly?
That's in here somewhere.
Okay.
Under separation.
Is it related to FMLA though? I do.
It could be.
So I
It
think-
doesn't have to be, FMLA is simply a job protection statute that says you get up to 12 weeks of paid or unpaid leave for certain conditions. After that 12 weeks is over, however, FMLA is off the table. We've given you all you're entitled to under the federal law. So then it becomes a management issue of how much more longer after that 12 weeks do we have to suffer with this person not being here? And so now you balance, the sympathy for the person versus we are an employer, we have a mission to do, taxpayers need the money, or not need the money, need the service. And so at some point, if the employee is saying, look, I don't know, I've got another surgery coming in 2 weeks or 2 months or whatever. Management may have to make the very hard decision to say, I'm really, really sorry, that you're in this situation, but your job is to, be a waste hauler or whatever, and you've got to be able to pick up these cans.
Yeah.
And if you can't, then we have to separate you. And we're very sorry about that, but that's the way it is. And I just, if that's not spelled out in there, I would want that to be
It's in
spelled out.
there.
Which section and
I think
I
it's
think
towards-
1102 mentions being separated if a physical or mental impairment prohibits them from performing essential functions of their position with or without reasonable accommodation.
I guess if.
Yeah, and we haven't gotten to 1102 yet, but I wouldn't necessarily say that we're kind of putting ourselves in an unnecessary box by saying in all cases, such separations shall be supported by medical evidence acceptable to the city manager. It may not be that we have medical evidence. It may be simply the employee's representation. And in my career, that's more often than not, when someone is separated for inability to perform, it's not because their doctor has put some document together saying they're not able to perform, but it's the employee, him or herself, saying, look, I can't perform. I still need to be off, blah, blah, blah. And so if we keep this policy as written and the employee keeps telling us that, but we don't have medical documentation, now we're not able to separate them. So I think it's better, and maybe just look at how I worded mine in whatever it is. Mine is disability leave, section 7H. And look at some of that language, but we haven't
You
gotten.
suggest putting that then in section 11, just to beef up section 11, or do we include it here with FMLA?
Well, I think
What's
it's-
your recommendation? Rob?
It's already in 1102, so the cities is organized differently. All I'm saying is that wherever we put it, we just need to say, if you're unable to perform your duties due to a disability after your FMLA protections are gone, then the city will separate you from them. That's really.
Yeah, Megan, could you put up section 1102 if you don't mind? And it'd be, I think when you read it,
1102.
44 of 94.
and I think going out of order, in my opinion,
Yeah,
if
you're
the
too-
conversation's
far.
flowing, then it
Mhm.
makes sense. Are you?
Yeah.
please? Up a little right there. So it says, an employee shall be separated when physical, mental impairment prohibits them from doing their functions. In all cases, such separations shall be supported by medical evidence. And that's the part you're saying that is really, can make it difficult for the city. And so it doesn't, you do not need medical evidence. It's just that if they still cannot perform the function of their job, that, the city may require reexaminations at the expense to be performed by a physician of its choice. Such examinations may include physical and or mental evaluations, as well as complete current medical history. So you're saying it's sufficient to say that if you can't do your job after 12 weeks, then we can part ways.
And Rob, your concern is with the concept of needing a medical.
Right, you're just, because their lawyer is gonna say, aha, you can't separate my client because you don't have this medical documentation, and your own policy, even though the law doesn't require it, your own policy says that you must have this before you let my guy or my girl go. And so it could put the manager in a box because the manager knows that the person's not coming back because they've already said they're not coming back. But, or that they're still up in the air and who knows how long, more months it's gonna take, and this surgery may or may not help them or whatnot. But they've long been past their FMLA leave protection. But because our policy says that the manager must have this documentation, which presumably comes from a doctor, then we're all sitting around waiting until we get that evidence, even though all we need is, have they been given everything they're entitled to under FMLA? And once we check that box, are they still telling us that they cannot perform and it's up in the air? And look, we're not here looking to say, aha, at 12 weeks and 1 day, you're fired, right? I mean, because that's what some employees will feel. But the answer instead is that what we're looking to do is understand that as the employer, we need the option, all things considered, to be able to let that person go after they have been given their FMLA entitled leave. And I knew one example in my years at Manatee County. There was a guy in the building department. He had worked there 32 years. He developed a neuromuscular disease. The guy struggled to get up the ladder. At some point, he couldn't even climb a ladder anymore. They let him stay on the books way longer than normal because of his good service to the county, 30 years service. But that's a decision that employer made, a business decision that they made to keep that person on the books. But you could have another employee who doesn't have that level of, admiration or whatever, or it's a position that we've got to fill. We have a limited budget. We only have 2 people filling this job and one of you isn't here and we have no idea when you're coming back. So the other person that's in the job is working double time. We've got to let you loose. And so that's it. The management needs the flexibility. And I'm only saying that the language about you need medical documentation is not necessary. And if you read it like a lawyer, it's something that we get caught with, and then we won't be able to act.
How do you define the inability and in what section in either? Or how do you define when somebody is incapable of doing their job? And is that clear? Because that's one question that begs the question. I mean, I understand if you define them as unable to perform their duties, then you can say, okay, you have 12 weeks to figure it out, but where's that line?
Mr. Lilly,
So if somebody's unable, well, I mean, that would fall.
Well,
So
in that example or any
FMLA and
example.
ADA are 2 different things.
What was it?
FMLA and ADA are 2 different things, but they do interact.
Right,
They may.
right.
So, I mean, under the ADA, you would make an accommodation if you can.
In the latter situation.
Yeah.
Okay.
yeah,
But
that's,
if for some
And-
reason somebody, like a driver, loses their sight, or something like that, then, maybe, they can't do the job.
And do we have a clear way of documenting? I mean, is there a clear process of saying someone's no
It's
longer?
called the interactive process.
Okay. No, I'm,
Yeah.
this is,
well, so the first key to start with is the employer should, in drafting everybody's job description, and I'm sure Mr. Lilly has done this, to go through each job. And in that, you'll have a subsection, which is essential functions of the
Okay.
job. And because we all have jobs, and some of the things we do are ancillary, go get the boss coffee or whatever, but that's not an essential function of a job. But, how much you have to lift, ability to climb a ladder, all those things. For intellectual things, ability to sit for long periods of time and listen to commissioners talk, whatever the issue may be. And so once you get that list of essential functions, then when you come to this difficult question, can they perform the essential functions of their job with or without reasonable accommodation? That list of essential functions is what Mr. Lilly will be looking at in going through the process with the employee to say, okay, this function, can you do it or not? And then the employee will say, well, I can do it, but only if you give me a bigger computer screen with bigger words because my eyesight's gotten so poor. Okay, that's a reasonable accommodation. We'll get you your bigger computer screen. But then if Mr. Lilly gets to, okay, this line, can you do this? Climb a ladder. Well, no, I can't climb a ladder. I have muscular dystrophy. I am in a wheelchair from now on. Well, you can't accommodate that because climbing a ladder for a building inspector is something that has to be done because you've got to get yourself up in that attic to look at whatever it is that got installed. And so in that situation, Mr. Lilly would probably be having the difficult task of saying, I really don't think, you can stay in this job anymore, and so there, some employers that are larger, it would be difficult for this smaller government to have an alternative employment program where you help that employee for a period of time and say, is there any other job here in this organization to try to keep you employed that you could do, from your wheelchair and help slot them into it? But, we don't have here in Madeira Beach, we don't have a lot of that flexibility. We're pretty small. And so you don't want to raise employees' hopes to create that kind of a program only to dash them because we don't have anything to put them in. So at some point you just need to be able to separate them. And that's again, getting back to 1102, I would recommend taking out that language that we have to be in possession of medical documentation, because we could be, but it could just be working with the employee and the employee telling us, him or herself, I can't do this anymore.
Where I struggle with this, I've only dealt with employees who have said, nope, I can't do the job. And yet the physician says, yes, you can. So it was the physician's note that enabled us to terminate these employees because we've got evidence that, yeah, you should be able to do the job. So,
And those typically come from when you send someone for a fitness for duty or a second opinion kind of a
Yes.
thing. And the second opinion usually comes in more on FMLA, where they've put in an FMLA leave request and say, I've got what FMLA calls a serious health condition, which really, if you look at the definition of serious health condition, it's not all that serious sometimes. But be that as it may, so they put an application, employer doesn't believe them. So Congress gave the employer the right to say, I'm sending you to our doctor. And if our doctor comes back and says, no, you can, then under the FMLA, the employee could demand a third opinion, which will be final and binding. And, but if that third opinion comes back and said, no, this person can do their job, they don't need to be off for FMLA, then Mr. Lilly can say, okay, the third opinion has said, you need to come in. And if they don't come in, we're really not talking about a disability separation. We're talking about insubordination, that they're
Right.
being directed to report to work. They have no justification medically not to be, and they're not coming in. They're insubordinate, and let them go for that reason.
I guess I struggle then with how is it going to be perceived by our employees if we ask Laura to get a doctor's note, but we don't ask Clara to do it? It's,
So that's why you have a Mr. Lilly, because he is the traffic cop of the HR's policies application. So hopefully he establishes a good working relationship with the line directors. And so they all confer with him when they're making decisions about what to do. And so he's got his finger on the pulse of what are all the directors out there doing. And if one director is off in a different direction than what this organization wants to go in, then it's Mr. Lilly's job to get that director to come back in. And if we need to get the manager involved, get the manager involved. I'm a big advocate for allowing department heads, leeway to run their different departments as their philosophies see fit, like for issues of discipline. One director may see this issue as needing 3 days off. The other one may say, oh, that only deserved 1 day off. But for complying with like the leave law, you do need to have more consistency. So you're right there. But that's where you've got an HR director who will come in and say, look, nobody else in this employer is doing it this way, none of the other directors. So, you need to not do it that way either. And if that director fusses, and that's when you go and visit the manager, and he will make the final call about, he'll hear from the HR director, he'll hear from his other director, and then he'll give direction on what to do.
So
I
how
guess
do-
the key takeaway is that when we get to section 1102, the city will have had time to consider this discussion and make a recommendation about requiring or not requiring the doctor's note as mandated. Is that
Yeah.
fair
That's fair.
for going forward? All righty. Was there anything else, Christina, under that section? No? Okay, then.
We're on
let's-
708.
70.
Oh, what's the title of it? Leave of without pay or just with pay?
We are at. Go back.
609, aren't we? 609?
Yeah, I think we finished 608.
I wouldn't go with the numbers because I think they're.
I know.
I would just go
Um,
with the name with leave of absence, we finished FMLA and then we do we,
Yep.
other leaves?
And then still on, sorry. Leave of absence without pay, and I had written a note. Involuntary LOA.
Voluntary leave of absence.
Actually, can I just ask a question before we get to that? Because we were talking about what needs to be documented or not documented by a physician. That very last sentence about returning to work after medical leave, it says that they must be certified as able to return to work by a physician. Why would,
Well, that's
We were-
protecting us, because if somebody, I mean, the physician has the authority and the ability to be able to say, okay, you can do the job. We don't have that ability, we're not physicians, so that is to protect us.
And that is allowed under the FMLA, and Mr. Lilly is right. So here's what happens. Employee burns their 12 weeks. Employee knows they've just burned their 12 weeks. Employee knows that now we're in that danger zone where management may say, we've given you all you're entitled to, you know, where are you? So sometimes the employee will say, and this also can happen if they've burned through all their paid leave, because some employees, you know, are frequent leave users, and so they never have a lot on the books. And so they want to come back in because they're going to go into a no pay status. So for whatever reason, they start knocking on the door and saying, okay, I'm ready to come back now. But if they're not really ready to come back, all we're doing is inviting in a person who either won't be efficient because they're still not going to be healed, or they're going to get themselves injured on the workplace because they're trying to do something that they're not supposed to be physically doing yet. So that's why the FMLA law allows the employer to require a returning employee to get that certification saying you're all clear. I, the doctor, have looked at your job description and I am telling your employer this person's good to go.
I feel like I guess we're gonna get there when we get there, but I feel like that doctor's evaluation would be relevant for the 1102 section. I don't really feel comfortable taking it out there for exactly the reasons you just described. I feel like it gives us more of the city more cover if they're not just saying, oh, I don't think you can do this, but a doctor is saying they don't think that they can do this, whatever this is. But I guess we can discuss, we said we were gonna table that, but anyway, okay.
Good to speak up, and so the city can consider. I also have my concerns about taking that out, but I'm gonna trust your thought process on that
Yeah,
when
I'm
we
gonna
get
take a look
to
at it and see what we come up
1102. I hear both sides, and I guess my own experience, I've been saved by doctor's notes too many times to clear that.
So I think that what he's saying is with relation to FMLA was what I was understanding is that after FMLA leave is up at 12 weeks, you don't need to get a doctor's note. And I
Yes.
think that makes sense. So I'm almost thinking it's a both. There, I don't know how you would handle it, but he's saying that we shouldn't have to prove at the end of 12 weeks that you still have a medical condition.
Yeah,
Okay,
I'm
that makes
listening to
sense.
everything and
Yeah.
I have
Okay,
an idea.
yes, just for, yeah, that's my difference for you two. So I think it's almost a both or something. We'll see when we get there.
Bring it up with time to do some research, so. Can we move on to current section 609, leave of absence without pay? I have a note that speaks to the involuntary. An employee may be asked, may be placed on leave of absence without pay by the city manager, where the city manager deems it to be in the best interest of the city. And my question is, all right, we put them on this leave of absence without pay, and then after due diligence and investigation, we find out, oh, the employee was in the right. Or what happens then?
Them whole. We make them whole. They get their pay and whatever else that they
I don't see any language that covers that. I mean, before it says it's pending an investigation into the employee's conduct and potential disciplinary action. And so you want to strike that. I don't feel strongly one way or the other. But if I were an employee, I would feel like, well, that's not fair. You're calling me guilty before any kind of investigation.
So
Me
you're,
personally, I think that should go back in the pending. That was the prior city manager.
Yeah, okay. Yeah, I'm okay with leaving it in. And then saying, should however the pretty language is, but basically, if you're found innocent, then you get back pay. Rob, is there anything that I'm missing on this?
Well, I think it's kind of an organizational thing. The 609 is just sort of floating out there. And it appears right after FMLA. And so the reader isn't really led to, is this a disciplinary discussion? Is this a medical discussion? Is this giving me every possible reason that I could be on leave without pay? It's just, it's placed in an odd place. But I think taking out what was taken out in that first thing called involuntary, I support that because the manager needs to be able, as a general issue, to put someone on unpaid leave for things other than disciplinary investigation. There could be a variety of reasons that a person is put on unpaid leave. And so to add that language back in, you're going to create the argument that the manager's authority to put someone on unpaid leave is only confined to when they're under investigation for disciplinary reasons. Why would you do that to yourself? But then when you read the thing that I had a note that was most concerning is in the paragraph beginning, an employee granted a leave of absence without pay. It's like the third from the last paragraph. In excess of 12 weeks. So this makes the reader think we're talking FMLA-ish kind of thing, shall be permitted to return to work providing a vacancy exists in their prior position. So that makes me think that this section 609 isn't just talking about discipline, it's talking about FMLA because, but even there, we're not required to do that under the FMLA. I mean, if the person has been out longer than 12 weeks, the FMLA is no longer applicable. The FMLA's reinstatement rule is no longer applicable. So in theory, if you read this language as a lawyer, as it exists, if my person's been out a half a year, but then decides to come back because you haven't separated them yet, they shall be put back to work. Is that
get rid
Mm-hmm.
really
of that whole paragraph.
Yeah,
is that really what we want? I don't think so. But
makes sense.
I recommend striking that paragraph if it's the
Typically,
reason to.
if there's an investigation, we have to separate employees, sexual harassment, for example. We'll do leave with pay, which is administrative leave, a couple pages before. And then if you're found guilty, let's say, then it would switch while we go through the process of termination.
I guess I'm thinking of other reasons other than FMLA, why
But then what is
somebody,
the purpose for that long paragraph? An employee granted a leave of absence without pay in excess of 12 weeks shall be permitted to return to work, blah, blah.
Oh, I totally agree. That should go.
Okay.
Okay,
Yeah, I'm not
so we're gonna
arguing
strike
that
that.
point.
All
but
right.
I guess I'm wondering, like, if someone's spouse was, were committed to working overseas and they were on a 3-month or 6-month deployment. It doesn't say they have to. It says they providing a vacancy exists, so you're not, city isn't committing to holding somebody's job.
I don't know that is there a benefit to having it in there? If that's, I think that's different. That's military leave.
Could be military, could be, I mean, there's other reasons
Any-
why people's work takes them overseas for a short-term assignment, that maybe the family goes with them for 3 months, 6 months, and it would be nice to have them back. But I guess I see what you're saying. If you're not actually guaranteeing them a job.
Yeah,
then-
if you're not, if you're,
Then
if
there is
you're
no benefit.
leaving, I mean,
Yeah.
you know, if you're leaving.
But
Also
it's a
business.
short term, I don't know. I guess I'm somebody who has left for short-term overseas
Well-
assignments.
Well,
So I get
Congress,
more.
in terms of military deployments and military spouses, Congress has already done in its 2008 amendments to FMLA, which are spelled out in great detail in the policy that I had put together. That's already covered and Congress has already given them, and so every employer is going to follow that. But for the example you gave that has nothing to do with military, that's going to be a situation where that employee would approach the manager and say, look, my spouse has a once in a lifetime thing to go to Dubai and do this, awesome thing. And I've got to be with him for kids. It'll only be 3 months. I've talked to my coworkers. They're willing to pitch in, and I really love working here at the city. Will you please let me have this extended time off? And if the manager says, yes, this is a unique situation, very clearly is an exciting opportunity. And as long as your coworkers are willing to suffer through, not having you for those 3 months, I'll go ahead and let you be out of here for 3 months. The manager can do that. That's a one-on-one conversation that they have. I don't think you need to memorialize that in the policy.
So the recommendation is then we're gonna get rid of that paragraph, the employee granted a leave, because it doesn't really add any value.
Yeah.
All right.
Can I, or do we have more in this section? I want to make a general statement before moving on to the next section. I'll let you.
That's the only one that I have in that section. Yeah.
Okay, can I make a recommendation that it be considered a couple formatting things? The current policy or manual has like underlined, separating underlined sections. It's sometimes difficult to know where you're talking about different sections such as FMLA. I found this difficult to follow because then there's subheadings within FMLA that are still under FMLA, but it's also separated by an underline. A way to do that may be to use letters like you do in the fitness for duty to separate out the sections within a section. I'd recommend that be considered like involuntary and then other, it would be an A and a B. It's difficult to follow when you're reading. And the other one is that we consider a serif font. It's gonna sound picky, but it's your serif font allows for easier reading. Sans serif font makes it more difficult to read. And I find this difficult.
So which font do you want?
Ones with the tab, I don't care which, but it's a serif or sans serif. So sans serif means you don't have someone help me. Times New Roman, but it doesn't have to be that. It just has to have the lines at the end of the letters. It actually makes it easier to read. Without it, it's actually more difficult and taxing on the eyes.
I mean, I think we're gonna, once we get it put together.
Yeah.
We'll take care of all the
Okay.
formatting, the table of contents and whatnot. But I don't think that's an issue at all.
Yeah, like we had talked about, all these references to the past edits, like
Yep.
resolution 07, all that can just go away. You don't need that.
Is it possible to do that in the working version? Because it's tough to follow.
I can try.
Yeah.
My only fear is that this has been messed with so many times. I don't know if I'm gonna make it worse. You know what I mean?
Yes, sir. Yeah. Oh, I understand.
Yeah. I mean,
And the thing is, and I don't know if you know this, but at the end, you can just do compare two documents and it'll
Mhm.
just, okay. Because there was a comment about having to, show the differences, but it'll show them.
I
That-
just
that
want
was
to
it.
make sure
Thank
we
you.
close the loop on
Yes.
this involuntary. Heard discussion, but I don't remember. Sean, you were in favor of leaving in the pending investigation, but Rob, you're recommending that we take that out.
I thought Sean said, Sean,
So-
are you okay with removing the pending investigation?
I prefer to have it. I can always send somebody on leave with pay. You know. We needed to.
Oh, I think as an employee, I would feel insecure if for no reason whatsoever, I could put on leave of absence without pay.
That was my instinct, without saying, if you're found innocent, you're gonna get it back. This looks like any reason I feel like you're on, you don't get paid.
Yeah. And it doesn't say, how long either, so like. you can
Well,
adjust
it depends. I mean, every situation's different. You know, an investigation could take 20 minutes or it could take 3 or 4 days.
Yeah, like,
Would
By
we be
leaving
better
an
served?
investigation is good because then you know it's a serious matter that you would be put on leave without pay, not just.
Would it be better served to include this language when we talk about disciplinary actions?
That's-
Instead of in
it's-
this,
You'll see it come up. Because the disciplinary actions, there's like,
if it's covered there, then do we need to have it
I
here?
think that there's a question about organization in the document. Would it be more beneficial to separate out like the good things and the bad things so that like if you're looking at discipline, that's leave, well, would those all fall under that? Like,
Yeah,
can you separate it that way? Because it does seem like, you know, we are doing, sorry, my hands. We are doing a lot of flipping as you read stuff. I don't know if it's the nature of us having read a different version or if things are really out of logical order. So maybe we should consider that.
I mean, for me, it makes sense, but
I guess what's the final decision on this language? Pending investigation into the employee's conduct. Are you
Okay.
ready to make a final decision, Sean, or do you want some time to think about this?
the involuntary,
Under involuntary,
I think
yeah.
it should be there.
You think it should be
Yeah.
there?
And what was
I
the
think you're
reason,
absolutely-
Rob, that it should not be there again?
because it gives the employee's attorney an argument that if the manager attempts to put someone on unpaid leave for a reason other than a disciplinary investigation, that he has no authority to do so because the policy calls out pending investigation.
What other reasons would there be to place someone on leave?
Because I'm reevaluating your job, whether your job is going to continue to exist here at the city because we have a budget crisis. I mean, there could be many different reasons why you put someone on unpaid leave. That has nothing to do with their being under investigation for discipline.
Okay, so this.
We're an employer. We need to be able to say, you don't need to come in today. And we don't, you know, and certainly the manager's not going to do that for some arbitrary reason and wake up and say, well, I'm just going to mess with this person today. But if there are legitimate business reasons why that person, you know, shouldn't come in.
Is there language we could add that, you know, I mean, there's a concern about, I think, the way it's, you know, it may come off to an employee, or do you think that is not a huge factor here? I could see what you're saying, pending investigation, so separating it out from a disciplinary action, but then is there a way, I think it both stem from the need for more explanation from the employee's end?
Well, I mean, if it would be for me, I would just take out the whole involuntary paragraph totally. If you're going to deal with putting someone out of the workplace during a discipline investigation, I would put that in discipline, which apparently Mr. Lilly says it already is going to be addressed in that. And then in terms of other scenarios, you just address it in a different wording where you talk about the employee's scheduled work week and say that, you know, your scheduled normal work week is 8 to 5, you know, however, management will assign, you know, hours as they may. And it provides the same legal effect, which is if you're not scheduled to work that day, you're not going to work that day. So it freaks the employee out less, but it still gives the same.
So how do we summarize that? So it sounds like there's,
That might give you.
Yeah.
should we just jump to that? Or
Maybe we come back to
jumping?
that after we go through this.
See, I'm just, it's historically, I guess none of us in the room know why this thing was organized the way it was organized. But when I look at the totality of what is now 609, it's pretty clear to me that it probably had to do a lot more with FMLA than it had to do with discipline, because it follows FMLA. It keeps talking about 12 weeks and discipline has nothing to do with 12 weeks. So, and
Oh.
it talks about being reinstated and what your benefits are or aren't going to be. That's all FMLA-ish kind of stuff. This involuntary thing, I think, got stuck in there at some point, because you could see this was amended in 07 and 10 and so it's been touched a lot of times. So I think it's just, you've got several, it probably began life addressing one thing and then other things got stuck into it. Now no one knows what it's intended to be.
For that,
You know what? I think we could just get rid of the involuntary, because the next section, other leaves without pay may be authorized by the city manager for any reason, which is deemed to be in the best interest of the city. So why don't we just strike that
That's fine.
involuntary part?
I'm
Because-
fine with getting rid of it or leaving that
I-
little bit of language in. So let's get rid of it.
Okay, let's get, I think if we're gonna leave in the pending investigation, this needs to get moved to the disciplinary. If we're gonna leave it as is, it's redundant because it's covered under other leaves.
And disciplinary, it may be paid or unpaid. The manager needs to have that flexibility, because
Right.
there could be a situation where either what the situation is isn't all that serious, even if they are guilty. And so we're probably not going to fire them or whatever. And so you make it paid. Maybe they have a very sympathetic single parent situation at home, but then there are other situations where we know they're guilty. And all we are really needing to wait for is to gather the evidence that is sufficient to do the termination, but that may take a couple of months. And I had this example back in my career where we had a person who worked in animal services. And it turned out he was part of an identity theft ring operating out of Tampa and stealing people's phone information, inmates, stealing people's inmate information and selling it on the black market. The problem that we had is that the FBI had taken over the investigation. I, the labor lawyer, was telling the director, you can't fire the dude until you've got proof, some piece of paper that the person did this. And the FBI was telling me, ooh, secret, we're not allowed to reveal anything. We're the feds. And so we were stuck in this situation for 3 months before finally I got an attorney out of the Tampa Justice Department to tell the FBI to at least give the arrest affidavit. So we had a piece of paper and then we let the guy go. But we weren't about to let that person continue to earn taxpayer money sitting at home, because we knew full well he was going to be federally indicted. So,
Right.
so the manager needs the flexibility, which way to do that.
But that helps it
But
sink,
that-
so that other leaves though, that language, I think covers it.
Covers
I
it.
think get rid of that.
Yep.
And then I have a question. This is, the article is benefits. How is that a benefit?
Huh?
This is Article 6 is benefits. So I do think it's a little confusing. Leave of absence without pay is, yeah. So then I do not think that fits under there. So I would reconsider.
Good
Sean,
catch.
have you, and I think, have you considered the organization of the document as a whole, like as an exercise? And would that be something you'd be open to doing?
I don't necessarily have a problem with it. I mean, I'm kind of used to it, so.
But it's not a benefit, right?
Yeah,
That's not a benefit. That does not fall. I mean, it should logically fall. I mean,
What, leave of absence without pay?
yes.
Well, it could be a benefit.
How? This is,
If you're,
oh, okay. If you're asking to leave.
yeah, I mean, for example, if you have an issue with a child and you need to take
That's
4 days
FMLA.
off.
That-
Oh, that's FMLA. that's
Yes,
true.
so this is pertaining predominantly to when the city, and now in the way we've removed things, it's predominantly related to when the city has a business decision to make and you want to put someone on leave. If we're removing involuntary, and involuntary definitely would not be a benefit.
No, I agree with
So
that.
let's reconsider maybe, but is that a resolution, reconsider if that area, if that belongs, if we're removing involuntary and other, and just what's left of that really belongs in a benefit area.
I think if we remove involuntary, then it does belong there. Because then it's you, the employee, asking for leave without pay.
Well, not if
potentially.
we consider what he's saying. He's saying as a business decision, you can stop. So there are, I guess then the language should reflect it. I mean, the other leaves may be authorized. Okay. Okay, then that is, never mind. Then are we covered in the then a separate question. Now I agree, it is a benefit. Is there something that covers the city to say, like he said, we just need you to not come in. We have a financial crisis. Sorry, we can't pay you.
I think other leaves, any reason, right there.
Because you have administrative leave, but that's with pay. And
Other leaves?
And in that section, right below involuntary, it says other leaves.
So, but then that
Other
that
leaves
is no
without pay.
longer a benefit. That is a,
Or the employer asks, that covers both.
Okay.
So like if you were gonna go with your, again, we'll go back to the spouse abroad, or you have some opportunity abroad, I don't know, whether it is, or you wanna go down and help hurricane victims for a month, you know, and take an unpaid leave of absence to do some special thing, that would be a benefit to you to be able to leave this job and go do something for,
yes.
I said not 6 months, 6 weeks.
And now the reverse. Now, so that makes sense. Now, the other way is what we're saying is also me and I as the city say, we need to put you on leave. You're saying that that's still under the benefits. To me, that's not very clear as an employee. You're saying it's a benefit, but now you're also saying you're using it to as not a benefit. So to me, you would want to separate, although maybe it's a similar language, you separate those out. Does that make sense? So it's like, you're saying this is the benefit section. So everything in here should be to the benefit of the employee, I think is implicit in the way, right? As a personnel policy. So now if you as the city want to say, hey, we need to put you on leave. And they're going to say, you know, where does it say you can do that? And they're going to say, hey, it's in the benefit section. It's. Well, we
So
can
then-
table it and I'm
I
recommending.
I
we-
see your point, just if, move that language someplace else, but I'd rather we carry on and let the
Yes.
city take a look, or we can look, is there a better place for it? Otherwise, I don't have heartburn over leaving it there. If there's a better place and it's easy.
That's okay with me. What we
Okay.
can consider
it's-
having something that covers the city. I want to know if there's a section in here that covers the city to do leave without pay. That's not in the benefit
I'd have
area.
to go back and look at the scheduled work week and whatnot. I would think that the city has the right to say this week but that's in the scheduled work week that we covered. Hey, we don't need you this week. They're redoing all the drywall in the building and
Yes.
you can't work,
Right.
whatever the reason is. But that could be covered under,
So let's
So
do
let's-
that. Let's resolve to make sure that that's covered somewhere. And Sean, if you can let us know where that's covered, if it's adequately covered. And update language if it's not. Then we can carry on.
okay, on to current section 610, employee assistant program. There was reference to a mandatory EAP referral. Just shows. What did I mean by that? Is mandatory EAP referral covered? I don't know what I meant by that.
Like, can you mandate somebody has to have counseling? Is that
Yeah.
what you're?
I've done it a number of times, anger management. Yeah. And what happens is they'll go, I'll just know that they went. I don't know anything about what happened. I just know they're complying.
For a EAP. I think I meant that you refer it based on performance or The city manager shall contact the counselor. The employee will be instructed to arrange an appointment. It's left up to the employee, still responsible for performance. Okay. Oh, failure to report for mandatory referral may result in administrative leave pending disciplinary proceedings. So they have to go. They do have to show up. That's what you're saying.
Yep.
Okay,
If they
so if a
didn't, it would be
manager
an
said,
insubordination.
let's go with your anger management. All righty, so the answer is yes. They have to go. All righty. Or they will have considered to voluntarily resign. Is that the intent?
Well, they're insubordinate.
They're
They've
insubordinate.
been given a directive by management
Right,
of, look, here's the deal. You got into a fist fight with your coworker. You clearly have issues, so instead of firing you, we're gonna let you keep your job, but only if, in addition to this 1 week suspension we gave you, you go to this anger management thing. And it'll be set out in the memo, that the counselor will need to give Mr. Lilly proof that the person has attended the sessions that are required. You don't have to reveal what's been said in the sessions or whatever, but that the person is attending and that they are cooperating, in the process. And if Mr. Lilly gets something back from the counselor that either the person's not going or that they're going, but they're treating it as a joke, then they're fired for insubordination because they were told to go and to cooperate.
looking at the clock, we have 4 minutes to go. We have section 611, fitness for duty. And then that's the end of section 6. I know that I didn't have any questions or comments about fitness for duty, but let me open it up.
I don't.
Really?
Judith Ann?
Maybe I stopped reading.
Is that the format you're looking for under fitness for duty, that sort of thing?
Yes.
Okay.
Does that make sense though? When the FMLA, I didn't know if it was still under the FMLA heading and they're all, it's just,
Well, and plus it's, I don't know what the right word is. It's, with all the changes and everything, it's,
Yes.
it's hard to follow.
yes.
I don't disagree.
This is another section that addresses the concerns about the disability and whether the individual would be given accommodations. Should the language be similar? The fitness for duty versus the separation for not being fit for duty?
Same question here as to why it's in under benefits, so. And you're saying this could be from being language related to the FMLA.
Yeah, it really doesn't read as a benefit.
Should this be, this is really
Part of-
section 1102, but with more detail.
We'll take a look at it, where to put it.
Maybe we should just
I think
cut.
the benefit section needs a different heading. Like when it comes into the stuff we were talking about.
Yeah. So the action item is you're going to take a look at this, see if it goes someplace else or we rename it from a legal perspective. Rob, anything we should be aware, concerned about in this? Regardless of where it lands.
No.
Thank you. Well, lo and behold, we are at a logical stopping point at just about at our suggested stopping point. So, any other discussions that we should have before we close?
Can't think of any.
Anything from the city?
Nope.
Nope.
No.
All right.
But thanks, it's a good exercise.
Yeah, very good. Okay, so then, our next meeting is changed till, yep, till the 30th, late in the day. And when, again, I would like to request that if possible, we submit ahead of time comments. And section 7 is pretty small. It has to do with employee training. Section 8, accident prevention. Section 9, classified appeals. And then disciplinary action, I think, is a biggie. So if I could just ask everybody to get at least through section 9, your thoughts, and be prepared to spend a lot of time on disciplinary action for our next meeting. Okay. Claire, what would be the date that you would like to have all of our feedback to you so that you can collect it in time for the meeting? Okay. Is that? It's into our packet making. Okay. Now just print it out so that we could go through them. Okay, 7 to 10. Great.
Do you mind if I ask one more question, even though we're, sorry, Sean, I have a quick question. When you're training managers on HR and HR policies, do you have, I mean, do you use a computerized system or do you walk through? Okay. Okay, so you have, I guess for me, I'm also curious about like, I think you sent over, one of the things I'm trying to do separately, and I'll try to send this in, I keep meaning to send stuff in, but understand all of your policies as a whole, because some of that, some of these questions, I think you might have handled other ways. But do you have training, like, so for your safety manual, do you have each employee sign, like, and like when they join the city? That's what I was curious. I mean, do you have a summary that just states what all is given to the employees because I think we've gotten bits and pieces. I was looking back through today before the meeting, and like, yes. Yeah, okay, that'd be fabulous. Thank you. That's okay. That'd be good.
This one?
Thank you. Okay, that's it. And November 1st for the comments. Thank you.
Fine. I scribble. Okay. Any other questions, observations? All righty. Good discussion. I want to beat the gavel and close the meeting.
Fabulous. Thank you.
Thanks, everybody.